My name is Angela Lopez, and I am a shareholder and lead immigration section here in our office. With me presenting today is attorney
Michelle Alonzo. Thank you for having us. I'm also here as a shareholder, Cowles Thompson, the Immigration Practice Group.
Well, again, thank you. A couple things. We are recording this webinar, and so you will be getting copies sometime within the next few days. The great thing about doing webinars is that you don't have to wait to the end of the presentation to ask your questions. You're going to see at the bottom of your screen or up on your screen, depending on how your system is set up, there is a couple small boxes. One is a Q&A and the other one is a chat box. Please try to type your questions in the chat box. That's the one that we're going to be monitoring closely. And we're going to try to answer your questions throughout the presentation. Today, as the name says it, we're going to be talking about the executive order, expanding the restrictions on work visa, the restrictions already implemented, and the new restrictions on work visas. So the executive order, it was issued this week, but effective on June 24th, 2020 at 12:01 a.m. Eastern Time. Is a precise time. What this order is doing is extending the executive order that was issued on April 22nd, 2020, and expands the restrictions. If you recall, and we did a webinar not long ago, and if you need copies of that webinar, please let us know, where we talked about that executive order that was issued on April 22nd, basically restricting visas or immigrant visas to those people coming from other countries with green cards, okay? And so what this order is doing is extending that executive order with all the restrictions and adding new restrictions. We will touch on what the restrictions are, what are the new ones, what are the old ones, and what the consequences are during this presentation. Now, the termination, the effective order has a termination day of December 31st, 2020, and it might be continued as necessary. However, there is a review mechanism implemented in this order where the Secretary of Homeland Security, along with the Secretary of State and the Secretary of Labor, will be reviewing the order first in 30 days as of from June 24th, and then every 60 days thereafter to determine whether or not the executive order should stay in place, or whether modifications should be made, or whether it will stay as is. So there's hope that they will terminate before December 31st, or that they make changes that will make immigration again more feasible for those who are not in the United States.
Okay, so as Angela explained, what are we talking about with these executive orders? The one that's just been announced effective June 24th, as also a continuation of the April 22nd one as well. And basically, we are looking at suspension and limitation of entry. And this is for any person seeking to enter the United States. Now, we are discussing both immigrants, people who are coming in to permanently reside or intend to permanently reside in the United States, and certain non-immigrant visa categories, which we're going to discuss here in the next couple slides. Okay, so now let's review who is affected or who's being impacted right now with these executive orders. So the ones that were in place April 23rd continue to be impacted with this new June 24th effective executive order. So who is being impacted? Parents, adult children, and siblings of U.S. citizens that were in the process of trying to seek their immigrant visa, those are still being impacted, as well as the spouses and minor children of U.S. legal permanent residents who were in the process of seeking their immigrant visa. Again, those are people outside of the United States. If you are in those categories and inside of the United States, you're going to see, and we're going to clarify, you're not impacted, at least not through these two orders that are now in place and effective. So people who don't have an immigrant visa and invalid status as of April 23rd, those are the folks that are kind of caught in this whole umbrella. People with approved I-140s, visa lottery winners. Again, if you are outside of the United States, you are still feeling the impact of this executive order. And then these are also the people that are impacted are people who do not have what they call official travel documents. So whether that's a valid temporary visa that's in your passport already, or you'll see there's a couple listed down there, advanced parole documents, boarding foils, transportation letters. If you don't know what those are and you don't have them already, and you were in the process of getting them, well, you're being impacted. You are outside of the United States, and you are going to continue to feel sort of the impact of these executive orders that are effective, as Angela mentioned, through the end of 2020 now.
The other thing is that you're going to see a difference in colors, and we will, that's just to emphasize the changes. So go ahead. I'm sorry, Michelle.
No, that's great, because what we want to emphasize in particular is the April 23rd executive order was in place, and we were expected to hear something about it by no later than June 22nd. And lo and behold, we have this presidential proclamation, this other executive order that was announced on June 22nd, effective June 24th. So that's how we're seeing the continuation of this first order that we discussed in our first presentation, and adding more with this new executive order.
And I just think that there is where the main confusion comes along, because people were not sure about what happened with the first one and what is the new one, and what is all part of the same, as it is a continuation, which we were hoping the first one was going to be discontinued quickly, but it didn't. So here we are. Go ahead.
Who's affected? These are the specific categories that are listed and named on this particular executive order. So H-1B, we know those are specialty occupations. Lots of folks are on H-1B. It's a coveted visa category because it's dual intent. A lot of attorneys and a lot of beneficiaries, employees really like this visa, and it's a coveted one. H-2B are your seasonal workers. So that's going to have an impact on a lot of folks. H-2A is agricultural. That one is not listed. H-2B is the stepsister. That one is listed. So that's interesting. J visas and the Ls. And we're dealing directly with a lot of those categories and the issues and the impact of this executive order because we have clients in those categories.
Great. Well, great. So by now you already have seen the difference in colors, and what we're trying to do, and I'm pretty sure Michelle already mentioned this, and I'm sorry I missed the first part of the presentation. We highlighted in orange the new changes, because as Michelle mentioned, the executive order that was issued early in April, it was extended, and they added these other components. So continuing with who is, in this case, exempt, who this executive order doesn't apply to. So we see here that obviously, and what we've been telling people is people who are in the United States on June 24th, 2020. But if you really think about this is extending the order, we are looking at whoever was here before March, because since March, no visas have been issued. Actually, we've mentioned this before, is that what people didn't realize is that people stopped entering the United States, and the consulates and embassies stopped issuing visas back in March, even in some countries in February. So when the first executive order came out, I think it was the first time people realized, oh my goodness, the visas, what's going on? They had already halted issuing visas. So obviously people who are in the United States are not affected. We continue to file, and the Department of Immigration continue to process H-1Bs, Ls, Js, green cards. So that has not stopped. We have not seen any orders or any action on the part of the Department of Immigration or the Department of State or the Department of Homeland Security to prevent people from continuing filing new or renewal petitions. Also, it's not affected, it is exempt. obviously spouses of U.S. citizens, children of U.S. citizens under the age of 21, prospective adoptees. And this one is new because I think they missed including this one in the first order. So children who would age out of eligibility for a visa as a result of the suspension, and there's a bunch of other things there. But so who are these? As you might be familiar with the immigration laws, children can benefit from parents' petitions or other petitions up until the age of 21. If they turn 21, in some cases, people are able to preserve that magic age to continue with immigration purposes. And there's a formula for that. And we're not going to get into that today. But in many, many cases, once people reach the age of 21, they are out of the immigration process. And they'll have to look for other ways to obtain green card. So what they're saying here is those people or those children who would turn 21 and would be out of the process, out of the immigration queue, then to them, they are exempt, so they can continue with their immigration process if their parents are immigrating and are able to come or adjust or do whatever they need to do to become immigrants. Of course, also, lawful permanent residents are exempt. Remember, a legal permanent resident in the United States has pretty much same rights and obligations as a U.S. citizen, except for certain rights like the vote, or the right to vote. Legal permanent residents can vote, and some other federal benefits and things. But for the most part, they have same rights and obligations. We're looking also at...
oh, Angela, it looks like folks are having trouble time hearing you. I'm getting some notes about that.
Okay, I'm sorry again. Okay, so go ahead, Michelle, pick up from here and see if I can my microphone.
So, all right, if you guys can let me know if the audio is any better. But as Angela was explaining, those who are exempt. So recap in case you missed it, those who are inside the United States. So if you're in the US, you're fine. This is not going to be impacting you. Spouses of US citizens, children of US citizen under 21, or prospective adoptees, children who would age out of eligibility. So if we've been talking to you, if you're one of our clients about Child Status Protection Act, if you have an age out issue, you should be protected as well. And any lawful permanent residents, which seems to make sense. We can go to, let's see, the next slide, and there it is. So who is exempt? Like, who is untouched from this executive order? And it's a pretty small, narrow category of people. That first box is very, it's a lot of words, but I'll read it to you. It's people seeking to enter the U.S. on an immigrant visa. So remember, we talked about immigrant visas. People who are trying to immigrate that are outside are being not going to be allowed to. But if you are a physician, nurse, or other healthcare professional, or you're performing medical research, and all of this has to be COVID-19 related or COVID-19 outbreak related, you're allowed to come in. EB-5 immigrant investors, if you've participated in our previous presentations, you know about the EB-5 investment program and how those initial investment amounts have gone up. But if you're an EB-5 investor, rest assured they're not worried about touching you. And the people who are further importance to U.S. law enforcement objectives as determined by the Department of State and Department of Immigration, DHS. We don't know yet what that means, but it is written into the order. We've had people speculate, and at this point, I'm not exactly sure what that means. I don't know if Angela has any insight, but it's a law enforcement, it's an enforcement component. So those are the categories of folks that are exempt from this latest order. And then let's move on to the next folks who are exempt. Members of U.S. Armed Forces or their spouses, that one makes perfect sense. Special immigrants in the Iraqi and Afghani translators category, that is a special category that's been in existence for years now, and that one is still exempt. And then we move into this other one, people whose interest would be in the national interest as determined by Department of State or Department of Homeland Security. This is interesting. I don't know if Angela wants to address this. I don't know how's your audio, Angela.
Yes,
Can we hear you?
I believe it's okay. So what we're looking at this is people in the best interest or interest of as the national interest as determined by the Department of State or the Department of Homeland Security. And maybe a slide or two slides ahead, we're going to see some clarification on that. But mainly are those who are coming to the United States to benefit the United States. And on that, we made a notation because there is a classification for physicians that is called national interest waivers. And the national interest means that it is to the US benefit that an individual obtains an immigrant visa and come to the United States to work. So it's not only for physicians, there is also other categories more general, like maybe researchers or other people who work. It is in the US interest to bring them in to continue with whatever they might be doing. So this is a great category for specifically for the physicians we work with, but for people who are doing work in and on behalf of the United States that will allow them to come and continue to work. So that one and is broad enough that it can be applied in many different ways. The issue there is that it's up to the Department of State or the Department of Homeland Security to decide what is in the national interest. So for some folks, something might be in the national interest, but for the agencies might not be. So it's one of those things that we kind of have to wait and see how it works. Also, people who are seeking to enter the United States to provide temporary labor or services essential to the United States food supply chain. Keep an eye on that specific definition, food supply chain. So if people are seeking to come into the United States to provide labor or services, even if essential to the United States, but they are not related to food supply chain, they might not qualify. However, take a look at the prompt before, which is if it is in the national interest, then they might qualify. So I think that you can kind of play with those two because they kind of interrelate, but at the end of the day, it's going to be up to the agencies.
Right, and that's an important point. That there's a section that literally says it's discretionary. So discretionary is discretionary. There's nothing that if you meet 1, 2, and 3, you automatically get it. It's okay. You meet 1, 2, and 3, you can be considered. Maybe.
Then we go into who else is exempt. Well, we saw this when we did our webinar in April for the executive order. People seeking asylum, refugee status, withholding or removal or protection order, according to the Convention Against Torture. That's still in effect, and I think it's a fair provision because we shouldn't be penalizing those who need our help. And finally, this one, and it goes along with the one that Michelle was reading, that it was a long text, but that one applied to immigrants, people who are trying to enter with a green card. This one is a new one, so because it's in orange, that's how you know it is a new one, because this is related to non-immigrant visas, to the H's, to the J's, to the L's, the ones that are affected by this proclamation. And it specifically says that people that are critical to the defense, law enforcement, diplomacy, or national security of the United States, or that are involved with the provision of medical care, there goes our physicians, our healthcare workers, to individuals who have contracted COVID-19 and are currently hospitalized. Keep that one in mind because we're going to talk about that one. Are involved with the provision of medical research, at the United States facilities to help the United States combat COVID-19 or are necessary to facilitate the immediate and continued economic recovery of the United States. It goes back to EB-5s are not restricted, if visas are not, so people can come and invest in the United States. People in the national interest, kind of all ties in. The part that calls our attention in this new provision when it comes to healthcare workers is because they specifically say people who are affected by COVID-19 and are currently hospitalized. So that begs the question also, what about those who are not hospitalized that still need care? We still need the healthcare workers. And not every healthcare worker is going to enter the United States with an immigrant visa. Many, many, many of the healthcare workers that come to the United States come with non-immigrant visas and temporary visas and H's. Many researchers come on TN. Well, TN is not included, so that's a good thing. But the H's are. So that hospitalized word that is included there, that's one of those items that we are looking for the agencies to clarify. Because if we're only going to restrict it to hospitalized patients, many healthcare workers, especially physicians, are not going to be able to get through with an H-1B visa for the rest of the year. And that kind of, it really makes no sense. So I think that maybe that one at some point is going to be clarified further. But we can see that this new provision is kind of a catch-all kind of thing, because they include all kind of things and a bunch of people there, and to facilitate. I don't think it's, I'm sorry, I should not say facilitate, because nothing facilitates in these executive orders, but probably that can be used to claim the exemption. Then we go to who is exempt. So talking about non-immigrant visas, right? So you know, and you probably have heard us talking about the alphabet soup, because you can name a letter and there's a visa for this specific letter. And this proclamation only refers to a couple of visas, and very specific, because they are not being, they didn't say all H's. No, they say H-1Bs, H-2Bs, and left out H-2As, right? For agriculture workers. They say L's and J's, but they didn't include investor visas, E1, E2, or the visas for Australians, E3s, or O1s for extraordinary ability, or TNs, or J1s for physicians, because the J1 is very specific to trainees, and Michelle already went over that one. Doesn't include B1s or B2s. Those are the visitors, or the F1s. So those categories are excluded. And then a bunch of other categories that are not, like athletes and other visas. So those are not included, meaning people potentially could get in one of these visas. And I say potentially because right now, consulates and embassies are still closed. So nobody's getting in, nobody's getting appointments. I actually had a couple of clients that were able to apply and get an emergency appointment to go and apply for a visa at one of the consulates, in their home countries. They went to the interview, and then and within a couple of days, this executive order came out, and so the consulates decided to keep their passports until they got further clarification from the Department of State as to what to do with those visas that they did interviews on an emergency basis. These are physicians, because they need clarification as to whether or not those physicians can now enter the United States or not. So
exactly. And we had a couple of TN appointments that we were able to get on the books for July for several clients, and then we got blanket emails that all of those were canceled. And we've been able to secure tentative August dates, but it's our guess whether or not they'll actually keep those visa appointments.
And that probably, and here is the thing, what is really creating chaos is not as much as the executive orders, which by themselves are enough to create chaos, but it's the closure of the embassies and the consulates. So even if people are not included in these executive orders as being prevented from obtaining a visa, they can get visas because consulates and embassies are not giving interviews or setting up appointments or issuing visa. Actually, we've been told that they were supposed, there's some of the consulates are supposed to start opening in July. I believe it's the 6th. But then we also know that they are going to be opening, we will be opening gradually, meaning they're not going to be opening for everybody. They're just going to be opening for certain things.
Which goes to one of the points I made earlier that, each post we're having to monitor, because I wish we could say the Department of State was very uniform across the board, but they're not. They're operating in other countries. So a lot of them are subject to whatever the host nation is also doing in terms of response to COVID-19 and openings.
And also to the restrictions that the host nation has. Because even though there might be visas or the consulates might be issuing visas in some countries, there are restrictions and people can't leave, period.
Exactly.
Not only that, but also in some countries, there are no flights going in or out, even if there are no restrictions to leave the country, no flight. So it is a bunch of different factors that are affecting people's ability to move or come to the United States or leave, in some cases, the United States, because they don't have a country to go to at this point, because there are no flights or countries are closed to other people. So this just makes matters a little bit more concerning. But and I don't know, Michelle and I have been talking about that, but this is nothing new of what has been happening since early March. This one, this is also a new addition, and we had to include the entire language of this one, because we have been getting phone calls and emails from people who have been told or are scared, and I know in the social media world, this is circulating in terms that H-1B visas are going to be revoked, because those are the specific questions. How about with the H-1B visas that are going to be revoked? If you read this provision, it just says, the Secretary of Labor shall, in consultation with the Secretary of Homeland Security, as soon as practicable, meaning whenever, and consistent with applicable law, consider promulgating regulations or take other appropriate action to ensure that the presence in the United States of all aliens who have been admitted or otherwise provided a benefit, or who are seeking admission or a benefit pursuant to an EB-2, EB-3, that is pretty much every single professional that you can think of in the United States, or an H-1B, does not disadvantage United States workers in violation of section blah, 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 blah. Bottom line, it's up to them if they revoke visas or they deny benefits, or if they take away whatever has already been granted. This is so broad. This is so speculative, so difficult to define that, quite frankly, we wouldn't know where they would start implementing anything, because according to this, they can do whatever they want, whenever they want, to whoever they want. And that's not how the law works in the United States. So um, it is funny, but not fun, but it's not really funny that they included this language there. Um, I don't even know what they were trying to accomplish with that, right, Michelle?
Yeah, we're still trying to demystify this language because it seems to be precise. I mean, it names specific categories, and the question is why. I mean, if a lot of it, the focus is supposed to be essential workers and the food chain supply, that tends to be our non-professional workers. So the fact that they name our professional categories, the EB2s and EB3s, it obviously is there's a reason why we're going to be monitoring this to see what additional clarification they provide, because first of all, it's poorly written, or in my opinion,
Well,
and it doesn't get to the heart of what they're trying to say.
Yeah, I don't think it's only poorly written. It was not thought of enough. It is, whoever came up with this one has no clue how immigration works. Because honestly, EB2s, EB3s, and H1Bs, all are professionals, all the people who have been here. And when you talk about EB2s and EB3s, you're thinking about people who have been here for, in many cases, for years.
Yeah, and we're not even addressing the backlog of folks for certain oversubscribed countries.
And all of a sudden, you're going to take away the benefits. I want to see something done, because there's going to be lawsuits. I mean, we wouldn't be able to count the lawsuits that will come up if they try to do something with this one. So we're just trying to address with this one is that people should not be concerned at this point. I'm not going to say ever, because I can't, or we can't, but with this type of language, people should not be concerned about their H-1B visas being revoked, or their EB1, EB2s, or EB3 petitions being taken away, or any benefit already granted. That's not how the law in the United States works. So they will really have to go against many laws to implement anything that will resemble something similar to what they have.
And if I'll add, if you guys remember at one point in time, when there were some folks that were getting H-1B visas revoked, they were getting notices from the Department of State because it was found that they maybe had a DWI, some criminal offense. So you're getting these letters that say, we're revoking your H-1B. But we had to tell our clients, if you're present in the United States, you've been admitted in H-1B status, yes, you would have to, if you depart the United States, you will have to go back and get a new H-1B visa. But your status is still, you were admitted, you still have through your I-94 period, you're in lawful status. Despite them canceling or revoking your visa, you're here, you were admitted pursuant to that visa. And obviously, if you want to travel out and get that visa reissued, you'll have to address those issues. But in terms of having legal status here, they're fine.
Yeah, and good point, because there is a question about that says, can I renew my H-1B visa? It expires on September 1st, but I'm here in the United States. So if you're here in the United States, I would suggest just file an H-1B renewal, because like Michelle says, the visa, and we have addressed this before, a visa is just a document, or we call it the key, that allows you in the United States to come in, to enter the United States. But once you're in, what counts is your status. So if your status doesn't expire on September 1st, but it's your visa, then you should be okay. But if it is your status and your visa, then file for a renewal, because those petitions can still be filed. As long as you're in the United States, you can still file for renewals and extensions.
And since June 22nd, premium processing has been reinstated. So yes. So you don't have to wait the processing times or projected processing times of 4 to 6 months to find out if your H-1B extension status will be approved. You can file for premium like all our employers love to file.
Yes, although if you are in H-1B visa, premium processing It's not going to give you a status in terms that you don't have to have the approval in your hand to continue to work.
Yep.
There is an automatic extension for up to 240 days once
Yep.
you file the visa. The problem we see is that your driver's license will probably expire at the same time as your H-1B. And for the renewal of your driver's license, and that's because the motor vehicle office decided that immigration law was not enough. They do not extend or renew driver's license unless you have an H-1B approval in your hand or an EAD approved in your hand. So for that reason, many people ended up, like Michelle says, expediting the H-1B so they can get an approval quickly.
And also because of COVID and a lot of work from home has been approved, remember the H-1B is job location specific. So of course there's measures about how we're supposed to address that. So if you think this is just a traditional extension of status, if you've done this before, please pause and consult with us, because there are certain things and certain steps that need to be taken to ensure that your H-1B extension is viable and can continue under these sort of very strange times that we have.
Correct. We're going to get into a couple more questions that we have here. Let us go through this final set of slides because we all want to know how implementation and enforcement is going to be done. Again, as of today, we're still waiting for clarification and a bunch of different things, and there are many associations, agencies, and attorneys already contacting the agencies about clarification and these items, because honestly, the implementation is the part that the agencies have not done. Let me just leave it at that. Implementation is they have to come up with clear guidelines as to how this is going to work. Just having this executive order out there, suspending is not enough, because then what happens with the people who are exempt? What happened with those emergency situations or those cases that are really justified to come to the United States with any of those visas? How are they going to process it? One of the difficulties that we found when the first order was entered in April was to help people to contact the U.S. embassies or consulates in their home countries to request an emergency appointment. Yes, it sounded easy because, and Michelle explaining in our first recording, that they just needed to contact the consulate or the embassy directly and request an emergency appointment. Well, many of them have no way, they didn't have any information posted as to how to contact them to request the emergency appointment. So people didn't know, where do we send an email? Well, for the time being, to whatever they might have in their website. And sometimes they didn't even address the questions through their website. So it was tricky getting through the layers of bureaucracy, I guess.
I joke it was the left hand trying to catch up with what the right hand was doing.
That's what we saw. So getting those emergency appointments wasn't easy. Finally, they figured it out, and now they come up with this one. So implementation is key, and they need to make available the tools and the means for people to be able to make use of the exemptions and claim whatever they need to claim to come into the United States. Consular officers, and they have always said this, and it's not just in this proclamation, but I would say that every time there's something done in terms of immigration, or every time we do something related to immigration, we have to address this with people, because people who try to circumvent the law or through fraud or willful misrepresentation, they are going to be penalized. And yes, because that's fraud. That's fraud to the federal government. And there is no white lies. There are just plain lies. And if you misrepresent a fact or something just to get a benefit, you're going to be removed, or you're not going to be able to enter the United States. And if they denied a visa because of willful misrepresentation, which is a lie, very difficult for you to ever get a visa again. Right, Michelle?
Right. And Angela, that's a great point, because some of the folks have been trying to get a little creative and say, well, I have a B2 visa in my passport, and it's not expired, and I can come in on my B2 and then we'll just file a quick change of status and I'll start working. The problem with that, and we don't know so much what the problem is, but there is an intent issue. There's an intent if you come in on a B1 or B2, for example, as a tourist, that your intent is to come in temporarily for visit, tourism, whatever the case may be. But then to turn around and immediately file a change of status because you want to go from B to H because you're here, there might be some question about what your intent was when you presented that B1 to enter. And I think that's really the scary part when we're looking at this enforcement provision in these proclamations, is how far are they going to go into what your intent was when you sought admission into the country in the very beginning. So it may not be so simple as, well, I have this visa in my passport, I should be good. We're going to definitely want to explore that and go into timing and evidence if those are your circumstances.
Yeah. And that's not to say that if once you enter, if something changes that merits the change of status, that's perfectly legal. And we have had many of those situations. But just entering in B and a couple days later filing to change the status to something else is suspicious. And you don't want to be in a place where you have to defend yourself against the charge of willful misrepresentation with one of the agencies, because they take those things very seriously. So be careful, and if you know of anybody who is thinking about that, they might want to consult with an attorney before trying to do that, because they're going to be watching very carefully. And when I say the agencies, and the officers at the port of entry, they're going to be watching very closely who is coming in, what visas. And remember, they do take little notes in those computers that you see people, the officers, when you come in, they make little notations. And whatever notations they make, you want to be consistent with whatever you might do later on in regards to your immigration. So we're going to go into the questions, and we already have a very good questions here. We have been trying to answer some of them, but we have one of those questions was, if my spouse got his H-1B and I am his dependent, H-4, already in the United States awaiting status, was pending, my case was pending as of June 24. Does this affect me? Just keep in mind what we just said. If you are in the United States, you not only can file processes, but whatever process is already undergoing is fine. There's no issues there, even if the visas are still pending. Remember that if the H-1B visa is premium process or expedite, you are okay. The H-1B is going to be approved before your H-4 is approved. Let's go with the next question. But if people on H-1B who are here already in the US on June 24 for several years, what happens if in case they will lose their job? Michelle, you want to answer that one?
So keep in mind that your status obviously is tied. If you're on an employment-based sponsored visa like an H-1B, once your employment terms, or even if you're on TN, for example, you have your 60-day grace period. So that built-in 60-day grace period could be when you try to find a different sponsoring employer. And we could do a change of employer and extension of status if permissible in that situation. But then again, if you don't find anything, that is your 60 days from your term date is the last day that you would legally be permitted to be here in status.
Yeah. And just remember that just by being here for many years and for many, many years in H-1B visa, that doesn't give you anything other than the right to stay in the United States working. And if your spouse has been here for many years in H-1B, that means that he probably has one of the EB-3 or EB-2 petitions that approved to continue to extend the H-1B. If in the event your spouse has to leave the United States because he couldn't renew the H-1B and didn't find a way to continue to stay legally in the United States, those EB-2s or EB-3 petitions do not expire just because you left, as long as at the time of returning, even if it is an H-1B later on in the future, or when your priority date becomes current and you're able to complete your green card process, as long as there is a job offer on the table, you should be able to come in through your EB-2 or EB-3. Does it apply to J visas? I'm not sure what you're referring to, the J visa.
J visas are impacted by the executive order.
Well, yes, but depends. If you're in the United States, you don't have any problems. You can change the status. You can extend your J visa. Remember, if you're subject to the 2 years, because not all J visas are subject to the 2-year foreign residency requirement. But if your J visa is subject to the 2-year foreign residency requirement, you're not going to be able to just change the status to something else in the United States, because you will need a waiver. And if you have a waiver, then you change to H-1B status and you should not have a problem. Just don't leave the United States. Can you touch on Daca at all? Absolutely, we love Daca. Michelle, Daca, we're happy.
Oh, okay. So we're happy because so far DACA is still in place. What the question that remains open right now is based on the last year's Supreme Court decision that came down. How much time do we have before the administration introduces possibly a new, they go through the procedure to terminate it according to what the Supreme Court said. So DACA is still alive. It's still going strong just for renewals. The Supreme Court decision should allow for initial applications. Unfortunately, though, we haven't gotten guidance from the agency regarding their acceptance, which is unusual. In previous situations where a federal court has ruled, the agency oftentimes within 24 to 48 hours will issue a publication and notice saying, okay, pursuant to this federal court order, we're going to be accepting these, and until otherwise, right? The U.S. Supreme Court decision came down, and we haven't seen an announcement regarding the acceptance of the applications. Rather, we saw a different response from the agency. I don't want to go into what that response was, but it isn't anything that we can move on yet. So what we're doing is we're still pursuing our renewals. If you have DACA and you're up to, for renewal, please renew, be timely, even get ahead of it if you can. Initial applications, we've done several consultations. Folks are ready. As soon as we know that the agency is going to accept them, obviously we'll be more than happy to be retained and file those. But until then, we don't see any reason to take your money to prepare for something that we don't know that they're actually going to accept yet.
Yes. To that effect, what we have been telling people to do, if they can, is to start kind of gathering the documentation that is going to be needed to file for DACA. If it is the first time, you will definitely need quite a few documents. The requirements for DACA, you can visit our website. We have them there. Today is not about DACA, so we're not going to get into DACA in depth, but we will do a webinar maybe sometime in the near future once we know what the Department of Immigration is going to do or has clear guidelines. But the requirements are still the same. Okay, so that has not changed. So start working on getting those. So in the event when they come up with clear guidelines, you are ready. And we will do a DACA workshop later. But today, I don't think we're going to get into that much. one other question we have here, can I apply for an H-4 visa being out of the U.S. with my spouse currently in the U.S. with an active H-1B? I actually had to look it up, and I was doing some research on these this week because I have a client in this specific situation. And although there is no clarification, H-4s, and this is something that really made me sad, because one of the things that we're looking at is, remember how the administration has been focused on trying to change the immigration system to a merit-based system. And with all of these restrictions, what we're seeing is that's what they're doing. They're giving exemptions to people who are professionals, doctors and other things, investors and other things. But when it comes to the age, of course, they follow whatever affects the H-1B. And in the cases where the Department of Immigration has made exceptions to allow certain individuals to enter the United States in H-1Bs, they only issue the H-1B visa, but they don't issue the H-4 visas for the dependents. So what we're seeing is that the H-1B might get the visa, but the H-4 won't. Or if the spouse is already in the United States in the H-1B visa and the other spouse has to leave or has not been able to enter the United States in H-4 visa, they're not going to get an H-4 visa just because the other spouse is in the United States. And they are just applying the same rules that they had been applying when they were giving emergency appointments to people to obtain H-1B visas, and they were giving them only to the H-1B holder, but not the H-4s to the family members. So we're still hoping for them to make some exceptions, like for this one, that if your spouse is already in the United States in this visa, well, then you were going to let you follow to join. But it doesn't seem, specifically if you see what they did with this executive order, they were very specific to say H-1Bs and any dependents. They included them there. And that's what they had been doing with the emergency. So for the time being, no H's, H-4s or H-1Bs are being granted unless you're one of the exemptions. And if the exception only applies to the H-1B, not to the H-4, because the H-4 is not coming to the United States to provide the medical services or to provide the services that they're looking for to people to come into the United States to provide. So for the time being, H-4s are excluded.
Angela, there's a couple of questions that got dropped in the Q&A box.
Yes, I'm in the Q&A. Can you read them? I don't have access to the Q&A right now.
Okay, so the first question, I came here with my dad when I was 13. We didn't go to court, so we were supposed to leave the country, but my dad leaves me in the country. Can I still get any opportunity? That is for another presentation.
Yes, call us if you want to. We can help you out with that. And there's not only for the DACA presentation, but there are too many things there that we don't know to be able to give you an accurate answer.
But you do need a consultation.
Yes, definitely.
Okay, so the next question, if we have an approved H-1B petition but have to leave the country for an emergency and the consulate is open, will we be able to get a visa to re-enter the US because we have an approved petition? That's exactly what this order is addressing. If you leave, there's not going to be an H-1B visa, or like Angela even explained, for the dependents, H-4 visas to be issued, not through the end of the year, according to this order, unless it's under the exemption, and then only then for the H-1B principal.
Yeah, and the other thing, and this is being debated, and is one of those items that we're waiting clarification on, because the order, the executive order, specifically says this order doesn't apply to those who were in the United States on June 24th. So, you know, we belong to a bunch of different associations and different groups with attorneys, and we kind of see what's going on in the discussions. And one of the discussions is, well, then if it doesn't apply to those who were in the United States, and you were in the United States on June 24th, and you had you got an approved H-1B or an approved H-4 or whatever. If you go out of the United States, this executive order should not apply to you. Therefore, you should be able to get a visa and come back to the United States. Well, technically that's correct. I would not advise my clients to rely on that, to go out and try to get a visa, because just because the order says so, I don't know. I would need to see something in writing from the Department of State saying, yes, that's exactly what it means. We're in the United States, you got that visa, then you can go and get the stamp at the consulate. Other than that, I would not rely on that provision there.
Right. The language, it's funny, but again, we worry about the mechanics of it. Fine, we can argue that by the letter of the proclamation, you should not be subject to this. You should be able to get your H-1B visa. It's a separate, different fiasco trying to get you scheduled, getting them to actually give you an appointment, and then to see if they'll issue the visa. Because if they don't produce the visa and your passport, you're not coming back in.
Yeah. Correct.
So the next question. I'm doing a J-1 waiver, second year of the 3-year requirement, currently on H-1B. Once the waiver requirement is completed, will there be a problem if I have a job offer willing to sponsor a new H-1B according to this executive order?
We go back to if you are in the United States, and remember, you are in your second of the 3rd year. Who knows what this is going to look like next year, or in a couple of months, 6 months, in a year from now? My goodness. If anybody had told us we were going to be here a year ago, we would have laughed. But we don't know how it's going to be. But anyways, even if we are in the same situation in a year from now, when you complete your 3 years, if you are going to change your status, you're in the United States, and if nothing changes, then you will be able to file your H-1B visa petition to change employers, as long as you are done with your J-1 waiver 3-year requirement. So if nothing changes and we're still in the same place next year, you're going to be able to change employers filing a new H-1B. But I doubt that we're going to be in the same situation in a year from now.
Yes.
We're going to answer maybe a couple more questions, because I think we're running out of time. So go ahead.
This one's a good one. Do you expect USCIS to stop premium processing again, given the financial difficulty of USCIS? Now, this question seems to be referring to the recent news of furloughed employees by the agency. If you've seen it and you've been tuned into to social media, the first furlough notices for USCIS went out, and they're estimating it'll be about 70% of their workforce that is going to be furloughed. Now, the justification came about because they said that the workload has been reduced by 50% as of late. So, do the math. If they're working off of 50% less cases, then dropping your workforce and furloughing them up to 70% shouldn't have a huge impact. But that just is the question that remains. Once these employees go and they're furloughed, will they stop premium processing because they can't keep up with the 15-day turnaround? It's to be determined. I do suspect that we will see some disruption of premium processing before the end of the year. But that's just my opinion. I hope that they don't, because if anything, that's one way to get fees and to keep people employed. But yes, I anticipate a disruption.
I agree with Michelle there. And I think that many of the things that we can say now, they're speculations. Some of the things, the premium processing being one of them, because if they do reduce the workforce, it's not just the premium processing, but most of the petitions are going to be affected. And that comes along with a bunch of other issues that we don't even want to think about it.
Right, and premium processing is for your employment-based petitions. So if they're hitting employment-based categories, This is one thing. Employers don't like the, lack of finite answers within a certain period amount of time. So
Yeah,
that's my commentary on that.
One more question here, and I think we're going to close. There's one more. If I'm I'm in the United States, I have a J1, a J2, which expires soon. And I have to leave the United States after it expires, family emergency. How can I re-enter later, at least to pick up my stuff if it's not a humanitarian visa? I don't know, because if you are in a J1 now, if you are not subject to the 2-year foreign residency requirement, or even if you are, and you're able to apply for a visitor visa later on when they reopen, because remember, the B1 visas or B2 visas are not included in the executive order. You might apply for a visitor visa later on, come back and pick up your stuff, as you say. So it is a matter of when you'll be able to do so, because even if you're subject to the 2-year foreign residency requirement, you will still be able to get a visitor visa. It's a matter of when. One more, and I think we're going to be closing here because we want to respect your time. I will be qualified for an H-1B exception because I'm outside of the United States and I'm coming to the United States to treat hospitalized COVID patients. My wife has a B1. Can she come with me, or should I apply for a stamping now? Remember, as an H-4, she's not going to get an exemption. She will not be able to enter the United States in an H-4. She might have better chances of entering the United States on a B1 visa. However, once she's here, I would recommend not to file so soon to change her status to H-4 for the reasons that we outlined before. Anything else there, Michelle?
I don't see anything else, and I think our time is up.
Yeah, we had a couple of hands raised, and I'm sorry we didn't get to it. We welcome you to call us or send us an email to ask your questions, or even to schedule a telephone conference with us. Remember, we always waive our fees for consultations when we are done with our webinars and we are not able to answer every question. We just want to thank you very much.
Yep, and hold on, and one shameless plug. If you haven't had a chance to visit our website, it's www.myimmigration.visa.us. Please do so. We put a lot of our information on there, and we have links to our YouTube videos as well. So it's a resource that we want to provide you as well, and please be sure to also subscribe to our newsletter. We've been doing a lot of updates and alerts as these things come out. So if you're subscribed to a newsletter, you'll also get that, as well as information about all our webinars.
Great. And that's awesome. An awesome note to end this webinar. Thank you so much to all of you.
Thank you.
Happy 4th of July. And we'll see you probably in a few weeks, and we'll talk about Daca.
Bye. Thank you.